welcome to our new video. Today we're going to discuss something every business owner, creator, and copyright holder must know: the rules around copyright assignment. Whether you're assigning your work, receiving rights, or planning to register a copyright, knowing how long an assignment lasts, when it lapses, and where it applies is crucial to protecting your creative property and avoiding legal surprises. So, let's dive right in and make sure you're legally covered. Quest 31. Does a copyright assignment lapse automatically, or are there specific conditions under which it expires? Ans. Yes, under Section 19.5 of the Copyright Act 1957, if the assignee, the person who has been assigned the copyright, does not exercise the rights assigned to them within 1 year from the date of assignment, the assignment will automatically lapse, unless a longer period is specifically mentioned in the assignment agreement. Key points explained. 1. Default rule, 1 year limit. If the assignee fails to use or enforce the assigned rights, e.g. publishing, broadcasting, adapting, or reproducing the work within 1 year from the date of assignment, the assignment will automatically become void with respect to those rights. This applies unless the assignment agreement explicitly specifies a different time period. 2. Purpose of this rule. This provision is designed to protect the interests of the original creator or author. It prevents the assignee from merely holding rights without using them, which could otherwise block the author from further exploiting their own work. 3. How to avoid lapse. The assignee must act on the rights assigned, e.g., start production, publish, or distribute the work. Alternatively, the assignment agreement should clearly state a longer or indefinite period during which the rights can be exercised. 4. Applies only when use is not made. If the rights are actively exercised within the 1 year period, the assignment continues to be valid as per the terms of the agreement. Quest 32. What is the period of assignment if it is not specifically stated in the copyright assignment agreement? Ans. According to Section 19.5 of the Copyright Act 1957, if the period of assignment is not specifically mentioned in the assignment agreement, then it shall be deemed to be 5 years from the date of the assignment. Key points explained. 1. Default duration, 5 years. If the agreement does not state how long the assignee can use the assigned rights, the law automatically limits the assignment to 5 years. This means after 5 years, the assigned rights revert back to the original owner, i.e. the author or copyright holder, unless the agreement is renewed or extended. 2. Why this rule exists. This provision protects authors from unintentionally giving up their rights indefinitely. It also encourages assignees to use the rights responsibly and within a reasonable time frame. 3. Can this period be changed? Yes. If the parties agree to a longer or shorter duration, it must be clearly mentioned in the written assignment agreement. If specified, the agreed period will override the default 5-year rule. Quest 33. What will be the territorial extent of the assignment if not specified in assignment? Ans. According to Section 19.6 of the Copyright Act 1957, if the territorial extent of the assignment is not specifically mentioned in the copyright assignment agreement, it shall be presumed to apply only within the territory of India. Key points explained. 1. Default rule. Territory limited to India. If the assignment agreement does not mention where the assignee can exploit the assigned rights, geographical coverage, the law automatically restricts the assignment to the territory of India. 2. Why this rule exists. This is a protective measure for the copyright owner, usually the creator, so that their work is not unintentionally assigned for global use. It ensures that rights outside India, e.g. international distribution, broadcasting, publication, remain with the original copyright holder unless specifically assigned. 3. Can the territory be broader? Yes, the territorial extent of the assignment can be broader, e.g. worldwide or for specific countries, but it must be clearly stated in the agreement. Example: suppose a photographer assigns the reproduction rights of a photo to a publishing company, but the agreement doesn't mention any territory. In this case, the assignment will be legally understood as valid only within India. To assign the rights globally, the agreement must clearly state something like, the rights assigned herein shall extend worldwide. Legal tip for agreements. Always clearly define the territorial scope in your copyright assignment to avoid ambiguity. For example, the rights assigned shall extend to the territories of the United States, Canada, and Europe. Or, the rights assigned under this agreement shall be valid worldwide. Quest 34. Can an author relinquish their copyright? And if so, what is the process for doing so? And yes, an author can relinquish, i.e. voluntarily give up or surrender all or any of the rights that comprise the copyright in a work. This is permitted under Section 21 of the Copyright Act 1957. To relinquish the copyright, the author must give notice of their decision in the prescribed form to the Registrar of Copyrights. Key points explained. 1. Voluntary relinquishment. The author voluntarily chooses to give up one or more of their copyright rights. This may include rights such as reproduction, publication, adaptation, distribution, or public performance. 2. How to relinquish copyright. The author must submit a formal notice to the Registrar of Copyrights. 1. The notice must be in the prescribed format, which is available on the Copyright Office's official website. 1. Once submitted and accepted, the relinquishment becomes legally valid and effective. 3. Partial or complete relinquishment. 1. The author can choose to give up specific rights, e.g. only adaptation rights, or all rights under the copyright. 4. Effective relinquishment. Once rights are relinquished, the work enters the public domain to the extent of those rights. 1. This means anyone can use the relinquished aspects of the work without seeking permission or paying royalties. 5. Relinquishment is irrevocable. 1. Once the rights are relinquished through proper notice, it cannot be undone. The author cannot reclaim those rights later. Quest 35. What are the rights in the case of a literary work under copyright? ANS. In the case of a literary work, the author or copyright owner enjoys several exclusive rights under Section 14A of the Copyright Act 1957. These rights empower the creator to control the use of their work and to authorize others to use it in specific ways. A literary work includes books, novels, poems, essays, articles, plays, speeches, computer programs, tables, compilations, including databases, etc. Rights in case of a literary work include the exclusive right to 1. Reproduce the work, or the right to make copies of the work in any material form, e.g. printing, photocopying, or digital reproduction. This includes reproduction in any format, physical or electronic. 2. Issue copies to the public, or the right to distribute or make available physical or digital copies of the work to the public, whether for sale, rental, or free distribution. 3. Perform the work in public, or the right to recite or present the literary work in front of an audience, such as in public readings, dramatizations, or stage performances. 4. Communicate the work to the public, or the right to broadcast or transmit the work to the public through TV, radio, internet, streaming platforms, etc. This includes making the work available online or on demand. 5. Make a cinematograph, film, or sound recording of the work, or the right to adapt the literary work into a film, series, audio drama, or any audio-visual medium. 6. Make a translation of the work, or the exclusive right to translate the work into another language, to authorize someone else to do so. 7. Make an adaptation of the work, or the right to create derived works, such as turning a novel into a play, rewriting it for children, converting it into a screenplay, etc. Additional moral rights of the author, Section 57. Apart from economic rights, the author also enjoys moral rights, which include the right to claim authorship of the work, the right to object to any distortion, mutilation, or modification of the work that would harm the author's honor or reputation. For more detailed information, visit the official website of VMK Professionals, vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Quest 36. What are the rights in a dramatic work under copyright? ANS. In the case of a dramatic work, the author or copyright owner enjoys several exclusive rights as per Section 14B of the Copyright Act, 1957. These rights are designed to protect the creator's economic and moral interests in the work, ensuring that they have control over how it is used, adapted, or performed. A dramatic work typically refers to works that include a story intended for performance, such as plays, scripts, choreographed dances, and other performance-oriented works. However, it doesn't include musical compositions, which are covered separately. Rights in case of a dramatic work include the exclusive right to 1. Reproduce the work. The right to make copies of the dramatic work in any material form, such as in written, audio, or digital format. This includes the ability to reproduce the script or choreography in a variety of media. 2. Communicate the work to the public or perform the work in public. The exclusive right to publicly perform the dramatic work, such as in theater performances, readings, or dramatic readings. It also includes the right to broadcast, stream, or transmit the work to a wider audience via platforms like television or online streaming services. 3. Issue copies of the work to the public. The right to distribute copies of the dramatic work to the public, whether it's in the form of physical copies, such as printed scripts or DVDs, or digital copies like ebooks or online downloads. 4. Include the work in any cinematograph film, or the right to adapt the dramatic work into a cinematograph film, i.e., to make a movie or video based on the original work. This right allows the author to decide whether their play or dramatic work can be used as the basis for a film or series. 5. Make any adaptation of the work, or the right to modify, reworks, or adapt the dramatic work, including changes to the plot, characters, dialogue, or structure. This also includes adaptations for other forms like radio plays, musicals, or video games based on the original dramatic work. 6. Make a translation of the work, or the exclusive right to translate the dramatic work into other languages. This allows the author to control how their work is made available to non-native speaking audiences. Quest 37. What are the rights in an artistic work under copyright? ANS. In the case of an artistic work, the author or copyright owner holds several exclusive rights under Section 4C of the Copyright Act 1957. These rights allow the creator to maintain control over how their artistic creation is used, reproduced, and adapted. An artistic work can include a variety of creative expressions, such as paintings, drawings, sculptures, engravings, photographs, architectural works, plans and designs, works of artistic craftsmanship. Rights in case of an artistic work include the exclusive right to 1. Reproduce the work, the right to reproduce the artistic work in any material form, e.g. print, digital, or photographic copies. This includes making copies of the artwork through photography, printing, scanning, or even 3D modeling. 2. Communicate the work to the public, or the right to publicly display the artistic work, such as in art exhibitions, galleries, museums, or on digital platforms. This right also includes broadcasting or streaming the work for a wider audience. 3. Issue copies of the work to the public, or the right to distribute copies of the artistic work to the public, which could involve selling or renting physical copies or digital copies, like ebooks or online images. 4. Include the work in any cinematograph film. The right to incorporate the artistic work into a cinematograph film, such as using a painting or sculpture as part of the set design or including an artwork in a movie scene. This includes adaptations where the work is used as a background, prop, or visual reference in film or video. 5. Make any adaptation of the work, or the right to adapt the artistic work into other forms of expression, or to modify it for specific purposes, such as creating derivative works, turning a painting into a digital design or a sculpture into a 3D model for augmented reality. It also includes the right to use the artwork in commercial applications, like merchandise or advertisements. If you want to register a copyright for your work, contact VMK professionals today. We'll help you protect your creativity with a smooth and hassle-free process. Visit www.vmkpros.com or call us now to get started. That's it for this video. We hope you learned something new and valuable today about copyright assignment and how the law protects your rights. If you've ever faced issues with copyright agreements, or if you're planning to register your creative work soon, don't forget to like, share, and subscribe to our channel for more clear, simple, and business-friendly legal updates from VMK professionals. Thank you for watching. See you in the next video.